South African parents failing to pay private school fees are likely going to have their assets attached. Now, that's according to TPN Credit Bureau's data for both private and public schools. 30% of parents have failed to meet their obligations. A 2017 High Court ruling allows independent schools to seek attachment of the immovable property of defaulting parents. Joining us is Ashleigh Laurent, who is an attorney at TPN Credit Bureau. Ashleigh, thank you so much for joining us this afternoon. That's an alarming and a very scary consideration to think of for parents, considering, times are tough right now economically. And according to that latest data by yours on the school fees, whether it's public schools or private schools, in this first quarter, it's 30% of those parents who weren't able to meet those obligations. Tell us more.
Good afternoon, Masim. Good afternoon to your viewers. Thank you for having me. Yes, so basically what TPN from MRI Software has found in the first quarter of 2024, 30% of parents who have children at fee-paying public schools did not make a payment towards their fee obligations, where 22% on the other hand made a partial payment. In contrast, 15% of parents who have children at independent schools made no payments towards their fee obligations, and then 32% at independent schools only made a partial payment.
What happens in those cases? Let's talk about the public schools before we get to this ruling that was made about the private schools as well. What happens in those cases where parents cannot meet those payments at a public school? Can they then enter into some sort of an agreement, or how long can that agreement also extend for?
Absolutely, Masa. So the position in respect of our public schools is that parents are afforded more protection in terms of the South African Schools Act. In respect of attachment of immovable property, they are not entitled to do that. Public schools may not attach the dwelling in which a parent resides. However, parents can turn to their fee-paying public schools and seek an exemption, whether that be a full exemption, a partial exemption, a conditional exemption. And there's an obligation on the school to assist that parent in applying for that exemption. It must also just be said that a public school, a fee-paying public school, cannot pursue legal collection means until such a time as that they've confirmed that that parent qualifies for an exemption or does not qualify. It's also important to note that you cannot exclude a child based on the fact that a parent is unable to pay at a public school. So they cannot be suspended or excluded. And furthermore, both in respect of independent and public schools, you cannot withhold a school report or a transfer certificate because that would go contrary to the National Protocol of Assessment.
When it comes to private schools, I think, and thank you so much for clarifying with the public schools and the options available there. But when it comes to private schools, your data also found that 15% made no payments for fees. But when it comes to them specifically, you warn that this is not an ideal situation.
Correct, yeah. So the position in respect of our independent schools is that the governing document is the fee agreement. And so your independent schools have, because they rely on school fees, they are entitled to adversely list parents once they've met the requirements in terms of the National Credit Act. They're entitled to seek a judgment for the non-payment of school fees. Of course, due procedure must be followed in any of these processes. And then, of course, the independent schools are entitled to seek an order to attach movable and immovable property for the non-payment of school fees. Previously, the Supreme Court of Appeal had also confirmed that learners may be suspended or expelled if there's a material breach of that fee agreement by the parents. So, but that is an absolute last resort. The child's best interests are of paramount importance. So, there are several procedures a school must follow before attachment of property or before looking to exclude a learner in that respect.
How long the duration of those procedures as well before they can go for those avenues of attaching property or expelling or suspending a learner as well. How long does a parent or guardian have to have that arrangement with the school?
It would vary. Look, the school has an obligation to first follow procedures to see if they can maybe enter into an acknowledgement of debt with that parent. But in respect of, excluding a learner or suspending a learner, it's the absolute last thing that they can do. And they would have to provide sufficient notice. Usually it's about a term's notice before they can actually look at excluding that learner. And that is the absolute last avenue that they can turn to. In respect of attaching movable and immovable property, I think the guiding point would be previous constitutional court cases such as Jafta v. Skuman and the Van Rooyen v. Stolz case, which they considered several factors when declaring a primary residence of a judgment debtor who's a natural person executable. So they need to consider things like the circumstances in which the judgment debt was incurred, the amount of the judgment debt, the financial position of the judgment debtor, whether there are other reasonable ways in which a judgment debt can be paid. So they are going to check, the court will check whether they have followed that. In respect of that 2017 judgment, the court had considered the size of the judgment debt. It was quite a significant debt. We were looking at 627,000 rands of debt. So in that regard, they would definitely consider several factors. And so there are several aspects that they would have to consider before attaching immovable and movable property.
And how often do independent schools make use of this as well, since that High Court ruling in 2017? How common is this?
It's a good question, Masa. The general position is, I think schools have to weigh up whether it is worth pursuing, whether it's worth throwing good money after bad, and going down that route, because it's all the legal costs that would be incurred as well, and that process of going through that. So it really depends on the size of the debt incurred, and that is usually dependent on the school fees at that specific school, the number of learners which would at that school. So in respect of that 2017 judgment, they had 2 children at that school, which obviously meant a larger judgment debt and made it worth pursuing at that time. So it's really depends, and it's up to the school and the school's legal representatives to determine whether it is worth pursuing.
Staying on the independent schools as well, earlier we were mentioning how times are tough economically now too. Are we finding that more and more at these independent schools, guardians and parents aren't able to make those payments? And what advice do you give to those parents? Because we still have a good public school
Absolutely. So I would say that that parents are obviously seeking quality education for their children, and we do find that parents may be struggling. Inflation and interest rates are not helping them at this time, and so we find that schools are struggling to collect those outstanding school fees. But it's important to understand that parents must have an open and frank discussion with their independent school and say, we're struggling at the moment. Is there a fair arrangement that we can enter into? Perhaps, and that would be the better option, right? Than not saying anything at all, and then facing these legal consequences. Alternatively, there are still good fee-paying public schools and public schools as well. But I think at the end of the day, it's important for parents to understand that it would affect other learners as well and the quality of the education. The non-payments of the school fees for independent schools who are self-funded affect the sustainability of those schools. They fail to maintain school infrastructure, to pay teachers who need to fulfill teacher posts to ensure that class numbers remain an acceptable size, and provide the necessary resources for a quality education. So it's the best thing they can do is have that open and frank discussion with the school to say that they are struggling, perhaps enter into a fee arrangement, or alternatively find a fee-paying public school that meets their needs.
Ashleigh, thank you so much for your time and sharing your insights with us. That is Ashleigh Laurent, who is an attorney at TPN Credit Bureau.